Welcome to the Deep Dive. Today, we're cutting through some pretty dense EU customs law. We're focusing on something that sounds simple, but is actually a huge deal financially.
Right. It's about when governments or, customs offices mess up. They levy money. They shouldn't have duties, taxes, even penalties.
Yeah, and okay, they usually have to pay that principal sum back. We get that. But what about the interest? The money your business didn't have access to for months, maybe years. That opportunity cost.
Exactly. And that loss, that unavailability of funds, is the absolute core of this deep dive. We're looking at what the EU's top court, the ECJ, decided in 3 linked German cases.
Yes, Grafendorfer, Reher, and Flexi-Montagetechnik. German companies fighting German customs.
That's them. They all won their initial arguments about getting sums repaid, but the real battle, the sticking point, was about getting interest paid on that money, and crucially for how long that interest period should run.
So these cases really force us to grapple with a couple of big questions for EU law, don't they?
They absolutely
Right.
do.
First, what does it actually mean for there to be a breach of EU law that gives you this right to compensation? Does it have to be some huge error, like the law itself being wrong?
Or is a simple mistake by the local customs office enough?
And second, maybe the most important bit for businesses listening, how long does that interest compensation cover? Can national rules limit it, perhaps unfairly?
Well, our mission today is basically to show you how the ECJ tackled these, how it used some fundamental EU principles to make sure these companies got full financial recovery.
And in doing so, really forced national systems like the German tax code here to step up.
Precisely.
Okay, let's unpack this.
So let's start with the baseline. There's already established case law here. It's quite settled, actually.
Okay.
The rule is, if a national authority hits you with a tax, a duty, any kind of charge, really, and it turns out that charge breaches EU law, you have the right to get that money back. The principal sum?
Right, the repayment bit.
Yes. But, crucially, you also have the right to interest. And that interest is specifically to compensate you for not having that money available. It's that opportunity cost we mentioned.
So the general principle, recovery of sums paid when they weren't actually due.
Exactly. That's the foundation.
Now, that makes sense for, say, incorrectly charged import duties, or VAT, but does it apply if the money involved isn't strictly a tax or a duty?
And that leads us perfectly into the first case, Grafendorfer.
The poultry exporter.
That's the one. Exporting poultry carcasses. Back in 2012, the Hamburg Customs Office did 2 things. They refused Grafendorfer export refunds they were expecting.
Okay, so money owed to them was withheld?
Correct. And at the same time, they slapped them with a financial penalty.
Ouch. Why?
The Customs Office claimed the poultry wasn't of fair marketable quality under the EU rules. And the reason given, and this is where customs law gets wonderfully specific, was too many feathers and giblets left on the carcasses.
Feathers and giblets.
Good.
Right, so Grafendorfer was out the refund and had to pay a penalty.
Yes. But then, later on, a separate ECJ judgment clarified how to interpret fair marketable quality. And it turned out the Hamburg Customs Office had just, gotten the interpretation of the EU regulation wrong.
A simple misinterpretation.
Essentially, yes. So the refund was eventually paid late, and the penalty money was reimbursed. But Grafendorfer said, hang on, what about the interest?
On both bits, the late refund and the penalty repayment.
Them both. And the ECJ agreed with them.
Really? Even though they weren't traditional duties?
Yes. The court stressed that this principle of recovery, it's general, it's broad, it's not limited just to duties or taxes.
Okay.
Being deprived of an export refund you were entitled to because the authority made a mistake, or having to pay a penalty that was wrongly imposed due to a breach of EU law. Both situations, the court said, are comparable to wrongly paying a tax. In every case, you, the business, were unjustly deprived of your capital because of the authority's error in applying EU law. So interest is due.
Wow. Okay. That definitely broadens the potential liability for customs authorities, doesn't it? It's not just the money they take incorrectly.
It's also the money they wrongly withhold or the penalties they wrongly impose.
It's all about making sure that the EU right, whether it's a right to a refund or a right not to be penalized unfairly, is effective.
Precisely. It's about effectiveness.
Right. Okay, so that handles the types of sums covered. Now let's move to that second big question. What counts as a breach of EU law?
Yes, this was a major point of contention.
Because national authorities, they often tried to argue, didn't they, that a breach only really happens if the ECJ strikes down the actual EU law itself. Like, the regulation was fundamentally flawed.
That was a very common argument, yes. a way to limit liability, basically. But the ECJ firmly rejected that narrow thinking.
So it's broader than just invalid laws.
Much broader. The ECJ clarified that a breach of EU law can involve any EU rule, primary law, secondary law, general principles, and crucially, it includes situations where a national authority simply applies that law incorrectly.
Hold on, though. Is that entirely fair to the customs office? I mean, these rules are complex. Tariff codes, origin rules, anti-dumping. If they make an honest mistake in interpretation or get a fact wrong, should that automatically trigger full interest compensation, like they deliberately broke the law?
That's a really important point to raise. And the ECJ's logic here isn't about punishment or malice. It's about, again, effectiveness.
Protecting the company's rights.
Exactly. Protecting the financial rights that EU law gives you. If you were forced to pay a duty that, correctly applying EU law, you didn't actually owe, then your EU-derived right has been infringed. Full stop. The reason why the authority got it wrong matters less than the fact that they did get it wrong and you lost money as a result.
Okay. So the breach can happen even with a valid EU law.
Absolutely. The ECJ highlighted two main ways this happens in practice, and they line up nicely with our other two cases.
Okay, let's take the misinterpretation angle first. That was flexi-montage technique.
That's right. Flexi-montage technique imported some bolt hooks. The customs office just picked the wrong tariff heading under the combined nomenclature. A straightforward misinterpretation.
Resulting in higher duties being charged.
Correct. The ECJ confirmed that misinterpretation by the national authority is a breach of EU law, triggering the right to repayment and interest. The EU rule itself was perfectly fine. The application was flawed.
Got it. And the second type of breach, you mentioned factual errors.
Yes, and that brings us to Reher. Reher got hit with massive anti-dumping duties. Why? Because the customs office insisted the fasteners they imported came from China.
But they didn't, or couldn't prove it.
The National Court eventually found that the customs office had simply failed to prove the Chinese origin adequately. It wasn't necessarily that the law was misinterpreted, but that the factual basis required by the law to impose those duties wasn't met. An error in assessing the facts.
Okay, so failure to meet the factual conditions set out in a law.
Exactly. And the ECJ confirmed this too constitutes a breach of EU law by the national authority.
So essentially we have sort of a three-part test now for a breach triggering compensation. The underlying EU law is invalid, or the national authority misinterprets a valid law, like in Flexi.
Yeah.
Or the national authority misapplies a valid law due to a factual error, like in Reher.
That sums it up well. And what's fascinating here is the ECJ explicitly said that it doesn't matter how the breach is established. It could be the ECJ itself saying the law is invalid.
Yeah.
Or it could be a national court, like the German Finance Court in these cases, finding that the National Customs Office misinterpreted the law or got the facts wrong. Both routes lead to the same place. Compensation is due.
So the national courts have a crucial role in enforcing these EU rights.
Absolutely. Their findings of error are just as valid for triggering this right as a direct ECJ ruling on invalidity. It reinforces the system of judicial protection.
Okay, this clear definition of breach sets us up for the really big fight in these cases, doesn't it? The timeline for that interest payment.
Yes, the financial heart of the dispute.
Because even when the German courts agreed, okay, repayment is due, there was this national law getting in the way. Paragraph 236 of the tax code.
That's the one, and it created a major hurdle. Generally speaking, this German law said you only got interest for the period after you formally started legal proceedings, like filing a lawsuit.
So hang on. Let's say a company wrongly paid a duty in, 2018. They go through administrative appeals, maybe back and forth for years.
Right, gathering evidence, arguing their case.
And they finally file a formal lawsuit in court in, say, 2021. That German law meant they got zero interest for 2018, 2019, 2020.
That's exactly what it meant in practice. Zero compensation for the loss of use of that capital during those first 3 years. It was wrongly held by the authorities, a huge financial disadvantage for the business.
Wow. So for the listener, when we talk about the EU principle of effectiveness needing to be respected, what does that actually mean here? Is it just about things being quick?
It's more fundamental than just speed, though that can be part of it. Effectiveness means that the national rules and procedures for claiming a right granted by EU law cannot make exercising that right practically impossible or, quote, excessively difficult.
Excessively difficult. Okay.
Since EU law itself doesn't lay down the precise admin rules for paying this interest, how to calculate it, the exact procedure that falls to the member states. But Their national rules must comply with effectiveness. They can't undermine the very right the EU guarantees.
So how did the ECJ view that German rule, paragraph 236, in light of effectiveness? Did it make things excessively difficult?
It did. The ECJ was very clear. The fundamental requirement stemming from the EU right is that the interest must compensate for the financial loss, the unavailability of the funds for the entire period the money was unavailable.
The whole time, from day one?
From day one. From the date the sum was wrongly paid, or, in Grafendorfer's case, from the date the refund should have been granted. The ECJ ruled that any national law, like Germany's, that limits the interest period only to the time after formal legal proceedings begin, thereby cutting out that initial period where the money was already unavailable. Well, such a law is precluded by EU law.
Precluded? That sounds strong. What does precluded mean for that German law now?
It means it can't be applied in situations involving these EU financial rights. It's effectively invalid in this context because it directly contradicts the principle of effectiveness.
Why? Because it just doesn't fully compensate.
Exactly.
Yeah.
By denying interest for that whole initial period, the national law forces the business to effectively bear the financial cost of the authority's mistake for potentially years. The ECJ explicitly said this makes exercising the right to full compensation excessively difficult. This ruling is massive.
Yeah, it sounds like it guarantees potentially years of back interest that businesses might have lost out on under restrictive national rules.
It does. It forces national systems to align with the EU standard of full compensation.
Okay. Is there any nuance there? Did the ECJ say anything about requiring legal proceedings at all?
Yes, there's a small point there. The court did acknowledge that national law can require you to actually bring formal legal proceedings, as opposed to just making an administrative complaint, to ultimately trigger the interest payment. That procedural requirement itself isn't automatically against EU law. But even that requirement is still subject to the effectiveness test. It can't be applied in a way that makes recovery excessively difficult. The court noted this was especially relevant in cases like Grafendorfer's,
Where the customs office eventually paid up voluntarily after a separate ECJ ruling.
Exactly. If the authority corrects its own mistake before you formally sue, but after you've been deprived of the money for ages, they shouldn't be able to use the lack of a formal lawsuit to escape paying interest for that period. That would undermine the right.
Right, that makes sense. Okay, to really drive home why the ECJ was so insistent on compensation for the entire period, let's just quickly revisit the Reher case, the fastener case. You mentioned high anti-dumping duties.
Yes, it's worth understanding the context there. Reher's case, that C41920, it wasn't just about any old duty. It involved specific, definitive anti-dumping duties on iron or steel fasteners originating in China.
Okay, and why were those imposed?
The EU had run a big investigation years earlier and found substantial dumping from China. Imports had rocketed. Prices were seriously undercutting EU producers. So the EU imposed very high duties to counteract this.
We're talking significant amounts here, not just a few percent.
Oh, absolutely not trivial. For companies that didn't cooperate with the investigation, the countrywide duty rate was set at a massive 85.0%. 85%.
Wow. 85%.
Part of the reason it was so high was the refusal to grant market economy treatment to the Chinese producers, partly because the cost of their main raw material steel wire rod was found to be artificially low, likely subsidized, and didn't reflect market reality. So the duties were deliberately punitive.
Okay, so when the customs office in Reher's case made that factual error when they failed to prove the fasteners were actually from China and subject to this 85% duty.
The financial consequences for Reher were potentially astronomical. The difference between paying a standard low tariff and paying an 85% anti-dumping duty could easily bankrupt an importer dealing in large volumes.
So that context underlines why getting the compensation right and for the full period is so critical.
Exactly. When the financial hit from a simple administrative error, a failure to prove origin can be that devastating. The remedy, the compensation provided under EU law, has to be equally comprehensive. It has to cover the full loss for the full duration. Otherwise, the right isn't truly effective. The business shouldn't subsidize that kind of potentially catastrophic error.
Okay, that really clarifies the stakes. So let's try and boil this down. This deep dive seems to give us 3 really solid takeaways for anyone dealing with customs issues in the EU.
I think that's right.
First, that right to compensation repayment plus interest is broad. It definitely covers things like late export refunds and wrongly imposed penalties, not just standard taxes or duties. That's the Grafendorfer point.
Correct. Don't assume it only applies to duties.
Second, What counts as a breach of EU law is also broad. It's not just about the EU law itself being flawed. A simple misinterpretation of the law or a factual error in applying it by your national customs office is enough. Think Flexi and Reher.
And importantly, a finding of that error by your national court is sufficient to trigger the right.
Right. And third, and maybe the biggest headline,
Yeah.
national laws cannot chop off the interest period. They can't limit interest payments to only start after you file a formal lawsuit. Interest has to cover the entire time the money was wrongly unavailable, right from the beginning. That's the effectiveness principle in action, overturning rules like that German paragraph 236.
That's the core finding on the timeline, yes.
So businesses that won cases, but maybe only got partial interest under old national rules, might need to look again.
They certainly should. And this raises an important question. The ECJ has really put the onus on national courts now to police this principle of effectiveness very strictly.
So for you listening, if you're involved in any kind of customs dispute where you think money was taken or withheld wrongly,
The big takeaway is that this ruling confirms if EU law was breached, even through a simple error by the authorities, you are entitled to full compensation. That means the principal sum back plus interest for the entire period you were deprived of it. National legal systems just have to adapt to this EU standard.
so the final thought is really for the listener then.
Yes, you should actively be asking yourself, do the procedural steps my national system requires me to take to actually get this full interest payment, are they truly effective? Or are they, perhaps subtly, still making it excessively difficult for me to recover what EU law says I'm owed? That's the question to mull over.
A very practical and potentially valuable question. If you successfully fought a customs decision, definitely double-check that interest calculation and timeline. Thank you for joining us for this deep dive. We'll see you next time.